Number 155, Clarence Earl Gideon Petitioner versus H.G. Cochran.
We'll hear argument first this morning in number 86-1278, Hustler Magazine and Larry C. Flint versus Jerry Falwell.
The issue before the court is the admission in evidence of the defendant's confession.
The standard of review is de novo, by which I mean it respects the jury's findings of historical fact.
Goldberg's gone. I'm sorry about that, Ruth.
Welcome to another episode of De Novo, a Supreme Court podcast. A bit of a special episode here because we've got some breaking news. Just about 2 hours ago, the United States Supreme Court granted a stay that was filed by Donald Trump in his D.C. case related to January 6th. That application for a stay requested a stay in his criminal trial related to January 6th, the case brought by Jack Smith, so that he could appeal an issue of immunity. Donald Trump is seeking immunity because he is arguing and has argued to the D.C. Circuit that he should be immune from the prosecution because his activities on that day, January 6th, were in furtherance of his office of the presidency. That argument was not very well received by the D.C. Circuit, ultimately rejecting it and writing a full opinion, but they did agree to hear the case prior to the trial. And the Supreme Court likewise here decided to hear the case. Now, this is interesting because typically a federal criminal defendant does not generally have much of a right to go to an appeals court before their federal criminal trial. Most of us citizens, if we had a legal issue that we wanted to take up that we lost on, we would not be able to get the attention of the appellate court. We have federal district courts, that's the trial court. We have circuit courts, that's the first level appellate court. But then we have the Supreme Court, the highest level court, the highest court in the land. And usually we can't go through those steps and get all the way to the Supreme Court without having gone through a trial and lost. Donald Trump here twice has been granted a stay in the trial date for his criminal case in order for him to challenge the prosecution against him brought by Jack Smith on the grounds of immunity. And so in a one-page order, the Supreme Court said they will grant the stay. They will also grant his application, his petition for certiorari, which is his request that the court hear his case. The Supreme Court is a court of limited jurisdiction, meaning it is not required to hear every case in front of it or every case that's brought in front of it. And what you do is you file an application. I've done this many times with the court, and you ask them to hear the case. And in order to get that application granted by the court only takes about 80 cases a year. About 8,000 petitions get filed. But in order to get that application granted, what you have to do is show the court that this is an important legal issue, that there is a split amongst the circuits, or that there is such a compelling violation of the law or the Supreme Court's precedent that this should be heard, that this should be one of the 80 and not one of the 7,020 cases that get rejected every year. So it's a good idea for us to get into how some of these cases are selected. Obviously, Donald Trump's case is going to rocket right to the top of the pile. But typically, once you file a petition, the court gets to decide whether or not it's going to hear it during its term, October to June. That's where it hears these 80 cases. The clerks at the Supreme Court have the ability to review the cases and write generally a brief for the justices. And the justices will meet during the week in what's typically called the cert pool, and they'll have the ability to review some of these cases, or they'll come to a meeting to determine whether or not they should accept a case. Stays are treated a little bit differently. They go to the judge that is assigned to the specific district in that specific court. In this case, it was Justice Roberts. Justice Roberts is presiding over the D.C. Circuit, which means he gets the ability to have first crack at any stay that comes from a case in the D.C. Circuit. There's 12 circuits, 1st through 11th, as well as D.C. The D.C. Circuit Court hears appeals from all trial courts in D.C. This case is in a trial court in D.C., and because it was a request for a stay from the D.C. Circuit Court to the Supreme Court, it went to Judge Roberts. Judge Roberts has the ability to decide on this himself, or according to Supreme Court procedures, he has the ability to send it to the entire court. And that's what he did here. The first line of the opinion reads, "The application for a stay presented to the Chief Justice is referred by him to the court." Now, Jack Smith in this case requested to treat the stay application, the application filed by Donald Trump, as a petition for writ of certiorari. The reason he did this is to potentially speed up the timeline. If the court granted the application for a stay and then provided a time period for which Donald Trump could file a petition for writ of certiorari, Jack Smith would have to wait all of that time in order to have the Supreme Court review the petition for certiorari. And so he requested this, and this was obviously going to be granted because the court seems to be interested in disposing of the case as quickly as possible. Donald Trump obviously wants to drag it along, so he filed the stay without the petition for writ of certiorari in order to buy himself a little bit more time. Jack Smith wants and needs this case to happen before the general election. So Justice Roberts referred this to the whole court, which means all 9 justices sit in a room, not really sit in a room, but they could, and vote on whether or not they should grant this. Now, for a stay, there's 5 votes that are required. So the justices would have to cast 5 votes. I'm pretty sure we know who those players are, although the order doesn't specifically say who voted. It just indicates that there were enough votes for a stay to be granted. Now, interesting thing here about this case is that it only takes 4 votes to grant certiorari, to grant a case being heard. So there's a hypothetical possibility that 4 justices voted to grant it. But because if certiorari was granted, this case wouldn't be heard until the next term, which would be after the election, likely, and a decision wouldn't be after the election, a 5th judge could have jumped in and said, well, we'll also grant the stay, and we'll try to speed this case up a little bit. I mean, obviously, because certiorari was granted by at least 4 votes, you would have to grant the stay, because otherwise the trial judge would have to issue a stay because there's a pending case before the Supreme Court. So I think the decision could have really been made based on 4 justices, and a 5th vote could have been found just because it's nonsensical to have this case proceed without any sort of stay. The question that is asked by the court in this 1-page order that will be heard at oral argument, will be briefed, and will be decided upon is whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. The court says, without expressing a view on the merits, this court directs the Court of Appeals to continue withholding issuance of the mandate until the sending down of the judgment of this court. All that means is the Court of Appeals cannot really provide teeth to its decision, the prior decision, until after the Supreme Court reviews. Pretty standard stuff. The D.C. Circuit is not going to act on its prior opinion, given that certiorari has been granted, and then the application for stay was dismissed as moot. It's not needed because the D.C. Circuit will refrain from doing anything. Now, the case will be set for oral argument during the week of April 22nd, 2024. That's pretty quick. That means briefs are going to be due pretty early. The first brief, petitioner's brief on the merits, and any amicus brief, any brief that's filed by any other interested party, and I'm sure there's going to be a ton for us to go through before this case is heard, must be filed by April 22nd. Must be filed by March 19th, 2024. Then the respondent's brief on the merits, and then any briefs in support by interested parties are due on or before April 8th, 2024. This is really, really quick in terms of Supreme Court briefing. These briefs take a long time to draft. They require a lot of consideration. They have to be everybody's best work. some of the brightest brains in the Department of Justice, as well as Donald Trump's team, are going to be on this. And then a reply brief will be able to be filed by Monday, April 15th. So not too long after that April 8th deadline. At that point, the briefing will be in, and then we will have between April 15th and April 22nd to digest all of the briefs and prepare for probably what will be one of the most exciting oral argument sessions in my lifetime, probably yours, depending on how old you are. Maybe you were around for some of the older ones, Brown v. Board, or maybe some other interesting cases. But certainly we're going to break down every aspect of those arguments in the briefs as well as in the oral arguments so that we can provide as much context as possible to what is going on here with Donald Trump. A lot of people continue to ask me for predictions, and this is really difficult. Obviously, we have a very conservative court, but the thing about the court, it's very difficult for the court to be politicized. A lot of people think the court is heavily political. I just don't buy that so much because the court has to think with a very long lens. They may be slightly political. That's possible, but the reality is that when the court issues a decision, they issue it for both sides. So some issues can be political. Abortion could be a very political issue. But when it comes to things like presidential immunity, it tends to not be very political because what they decide for Trump is going to apply to Biden. It's going to be applied to future Democrat presidents. What they decide for the Colorado ballot case is going to apply to every other state that has its own primary elections and whether or not they will be able to take that sort of action. So while some people say, wow, this must be political because it's related to Trump, just remember that these justices are fully aware that once this issue is decided this term, it may not be decided again for 100 years. Might be 50. The Gratz case, the Bollinger case, the affirmative action cases that arose out of University of Michigan and other schools was well over 20 years before those cases were ever reheard and redecided. The abortion case, Roe versus Wade, the 70s. It took many, many years before that was decided. So a lot of these decisions will be set in stone for a long time and apply to both sides. I don't see this as much of a political issue as I do a difficult question regarding presidential immunity. Now, I think the arguments that are coming from the left, probably the strongest point is if you immunize Donald Trump, then he could have, flagrantly killed somebody and he would get away with it. And is that what they're really suggesting? There was a question like that coming from one of the judges on the DC circuit. And it was a very good question, a very valid point. And I think the answer from Trump's side is, well, then he would have to go through impeachment proceedings. And if he was impeached, then he would be able to face prosecution. Jack Smith's team believes that once you're out of office, you can face prosecution for any crimes that are committed while you're in office. But I think what the court is probably going to look at is whether or not this was activity that was in the scope of his job as a president. And here's why this is really important. And this kind of is something that applies to every employee. If you are working for your company and you're sued, you're a representative of your company can be liable. They get a lawyer. They take care of it. You're a driver for your company and you're sued. You're in the scope of your employment. But then when you deviate from your trip, you decide that you want to go to the roller rink when you're supposed to be working and hang out and have a couple beers and you get into an accident. I don't know who's drinking at the roller rink, but it's the first thing that came to mind. Once that happens, you're outside the scope of your employment. Your employer could be liable, but they'd really have to they'd have to do a good job of showing that they somehow knew that this was going to happen or somehow allowed it. And that's where this distinction is really important, because a president shouldn't be able to be prosecuted for the actions that are taken that are in the scope of their job duties as a president. If he is engaged in a presidential duty and it is determined that that duty was somehow wrongful or illegal, a president shouldn't be prosecuted. And typically, prosecutors can't be sued for the things they say in court. Police officers, for the most part, can't be criminally prosecuted or sued for the things that they do that are in the scope of their functions as police officers. It's when they deviate from those functions that they get into trouble. So that's really the question that I think the court is going to try to answer. And unfortunately, that's a very difficult, fact-intensive question. And at this stage of the proceedings, the Supreme Court doesn't really have the facts decided in order to rule on much of this. And that is the problem facing the Supreme Court right now. They've decided to take up the case of immunity before the facts have been determined. And when I say before the facts have been determined, certainly we've had the January 6th committee. We have the report. We have evidence taken. Colorado had their funky little 5-day proceeding where they basically just moved the January 6th report in. And those are certainly factual findings, but those do not apply at this appellate stage. The reason why is because a trial is where we determine the facts, and we have not had a trial yet. So the motions of Jack Smith, the investigations of Jack Smith, the testimony, that stuff will not be heard before the Supreme Court of the United States. The only issue on the table, as we read from the order, is whether a former president enjoys presidential immunity from criminal prosecutions for conduct alleged to involve official acts during his tenure. Let's go back to that phrase, official acts during his tenure. You could say the Supreme Court is already determining that these are official acts. Or, and this is really, really the most important finding from this one-page order that we could really draw, or the Supreme Court is only going to decide the narrow issue of whether he gets immunity from his official acts, not whether he gets immunity from his unofficial acts, which means the January 6th trial could go forward if the Supreme Court even sides this in Donald Trump's favor. But the question for the January 6th prosecution in D.C. District Court is going to be whether Donald Trump was engaged in an official act or whether he was engaged in an independent act. I expect a decision from the Supreme Court, likely to immunize a president engaged in official acts, but not say whether or not Donald Trump was engaged in an official act, and leave that up to the ultimate fact finder. That's where I believe this case will resolve. That's where I believe the justices would be most aligned. That's where I believe the country benefits the most. If a president takes an official act, they can be immunized for it from at least criminal prosecution. They can certainly be impeached from office, and rightly so. They would be stripped of their power, but they could not be criminally charged. But if a president decides to pull out a gun and shoot a member of Congress in the head, that would not be an official act. That would be a criminal act, would be subject to immediate criminal prosecution and impeachment at the same time. And that certainly is not something that the Supreme Court wants to stand in the way of. But they do want to allow free, non-politicized decision-making by the executive of the United States, and they don't want to favor future criminal prosecutions. To those who may in the comment section still suggest that the Supreme Court is making a politicized determination, imagine this. Imagine a day where Donald Trump gets into office and he wants to prosecute President Joe Biden for things that he did, or he wants to prosecute Merrick Garland for things that he did. Those two are going to want to enjoy immunity for their official acts so that they do not even have to go to trial for those things. Just a trial alone, the agony of a proceeding like that is enough to harm those two individuals severely. Bond restrictions and indictment and going to court and potentially having a jury that doesn't look favorably upon you. Oh, that whole process is unnecessary if somebody's going to engage in a political prosecution for your official acts. It's so unnecessary. But it is completely necessary if somebody's engaged in an individual criminal act. This is where the rubber meets the road. This is where the DC Circuit got it wrong. They didn't see the distinction. This order tells us everything we know about what the Supreme Court is likely to do. And I really don't need to see much more before understanding that this is the best thing to resolve this case, to allow Donald Trump's trial to go forward, to provide proper restraints on the DC District Court so that we're not engaging in a contest, a future contest of official acts by presidents, and so that we can have an office of the presidency that's free from those sorts of criminal prosecution worries, but we can also hold criminals responsible for what they need to be held responsible for. Then a DC jury at some time may decide this. The next question. Everybody wants to know, and I'll be live on Scripps News tomorrow morning answering exactly this question, and likely on News Nation later in the day. The next question is, will the trial happen before the election? That's a difficult question. I feel like this trial could be one that takes 6 months. Jack Smith is pretending that this trial is only going to be relatively short, a month, 2 months, whatever. I'm not sure what the official amount is, but he thinks it's going to be pretty short. I absolutely disagree with that. The January 6th commission was not quick. This is going to be a redo of that. There's going to be a significant amount of evidence, cross-examination. The OJ trial took a year. This trial could easily take that much, possibly shorter. And I think with the amount of discovery, the amount that's left to do in this case, the amount of important legal issues for our country, racing this trial forward before an election makes absolutely no sense from a justice standpoint. Now, I understand that the nation wants a decision on whether or not the frontrunner for the Republican Party is eligible to be in office. And the Supreme Court is going to hear that case and decide that as well, based on the facts that they have available to them. But as it stands right now, there's simply no time to get that trial done before an election. And it seems that the public will get to decide. And that's really what's perfect about this system. The public will get to decide whether or not somebody can take the office of the presidency pending a trial like this. If the public says yes, then it seems like they're voting that this is a political prosecution and they still trust a guy like Donald Trump to run the country. If Donald Trump doesn't get in office, then they're saying, no, we would still rather take Biden, despite maybe some of our issues with him, despite maybe the Gaza issues and the issues surrounding his age and ability and the potential that we may have President Kamala Harris in office. If they vote for President Biden, they are saying we can't allow Donald Trump in office in these circumstances, and that would be their choice as well. So even if the trial doesn't take place, democracy still has a voice. The people still have a voice. The vote matters, and people get to decide the direction that they want this country to go in. And I think it's important for all of us as citizens of the United States, regardless of what that decision is, to put our support behind the United States and the Constitution and the offices that are in front of us and work the system and the democracy the way it's supposed to be worked and challenge our systems inside of this democracy in an appropriate and respectful way, because that's what's important, the system, and ensuring that we're able to move through democracy in a civilized manner, using our vote, using our courts, the decisions of those courts, respecting those issues and knowing that they can be re-raised again and again and again until we feel a sense of justice. That's what happened in the civil rights movement. That's what's happened with issues like affirmative action. And that's what will happen with issues like executive power and presidential immunity and agency decision-making. All of these issues will be resolved by a court. They may not be exactly what everybody wants, but the country will move forward and we will see another day. So thanks for tuning in with me for this kind of late-breaking special episode of De Novo. I'm happy to bring it to you. I'm happy to be here along for the ride and to be hopefully informative about this important case so that you're not just reading these news articles, not really understanding what's going on. If you have questions, feel free to drop them right down there in the comments section. If you're on YouTube, you can do the same thing on Spotify. Feel free to let me know what your thoughts are. Ask any questions you have, and I'm going to try to get to all of them. And if I can't get to all of them, I'm going to try to wrap a lot of them up in the next episode when I jump on and talk about new developing issues related to Donald Trump and the Supreme Court. This is Ron Chapman, February 28th, 2024. Donald Trump presidential immunity being heard by the Supreme Court with an oral argument date set for April 22nd, 2024. Briefing to be completed by April 15th, 2024. As always, you can find me over at my website, ronaldwchapman.com. There you can find articles related to all of this, notes, cases, additional reading and information, and even a few videos. Ronald W. Chapman.